right. Hello, welcome everybody. I'm Joanna Lee, the Vice President of Strategic Programs at Legal at the Linux Foundation and CNCF. Shane, maybe you can go next.
I'm Shane Coughlan, the General Manager over at the OpenChain project. We deal with standards around open source business process management.
Hi, I'm Van Lindberg. I am an IP lawyer and I run OSPOCo, which is an open source program office as a service company. So we help a lot of companies with their OSPOs.
And so today we're going to talk about legal risks and other challenges associated with generative AI, some best practices for risk management and compliance, both within companies and enterprises and also within open source software projects. And we'll talk a little bit about AI tooling features that help with compliance and legal risk management. So we'll talk about the legal risks, some of the legal risks and challenges first. We'll start with some of the copyright issues. So under current law in most jurisdictions, only creative works that are authored by a human being are copyrightable. So works that are authored by an AI tool, a machine, a monkey are not copyrightable. Although an AI tool can't, under current law, be the author of can't be the copyright holder, so that the works that it creates don't qualify for copyright protection. That doesn't mean that an AI tool can't be used to infringe existing third-party copyrights. So an AI tool, is going to train on lots of training data, and if the data that it trains on is copyrighted material, and then the AI tool reproduces that copyrighted material in its output, the output could be infringing. And so these are scenarios that are basis of some of the pending litigation regarding generative AI tools. There is some uncertainty about the training part of AI. So when an AI trains on copyrighted material, is the actual training, is that copyright infringement if it's training on copyrighted data? And this is not settled law. There's some uncertainty about this both in the U.S. and in other jurisdictions. I mean, my personal opinion is that it's fair use, because a human being can read hundreds of articles, look at thousands of paintings, et cetera, learn from those and be inspired by those, and that's not necessarily infringement. So my personal view is a computer doing something that a human being can do without infringing copyright is, it's well within, it's either not infringement or it's qualifies for fair use or similar exception, but this is far from settled law. So what we'll talk about later in the risk management side and best practices of copyright is really focused on what to do with regarding the risk that the output of an AI tool might infringe third-party copyrighted materials that it was trained on. And I'm going to turn it over to Shane for talk about licensing compliance, and just let me know when you want me to advance the slides.
All right, well, we'll stick on this one for a couple of minutes. So for some context, I've been working around open source compliance management for around 20 years now. And we've seen a lot happen in terms of different approaches to software, different licenses around software, and different waves of people choosing one direction or another. Now, AI is obviously something quite new. It's a very fast-moving field. But on the fundamental level of software, it's not that different from where we've been before. And I think that's an important starting point when businesses look at how to manage AI. And when you're looking at how to manage the license compliance around AI, it's a good starting point to say what we've done with proprietary software, what we've done with open source software won't require a paradigm shift when we look at AI and software. So really, you're looking at the same fundamentals. How are the models and data sets and outcomes licensed? How will your company manage the approval and tracking and records? And how will you escalate new situations, new licensing, new requirements to the legal team? And those fundamentals should be in place in your company already, which will make the AI compliance regime, hopefully, a smoother process. Now, this is pretty much the same as we've seen with open source software. I mean, you're looking at, once you've identified the license, determining, is it on your approved list? Is it something that your company knows it can work with? And is it something that you're able to record effectively? And can you decide if licenses, if requirements fit with your corporate strategy? All of these things are the same questions we've asked for many, many decades around ingesting third-party intellectual property. Now, the interesting thing about AI is that it does add one new facet of license compliance management. It generates new code that may relate to other third-party code. And that's where you might have something that differs from the model, data, and outcome licenses you previously reviewed and approved, and it may differ from your expectations as a company using AI. This isn't a bad or a good thing, it's just a thing. It's a facet of AI that we need to consider and have management processes around. Let's go to the next slide, please. Digging a little bit deeper into that, we have this fascinating concern and potential around machines that learn. And as Joanna said, just like a human, things can be absorbed and then stuff can come out. What is a challenge is if the AI potentially produces software that aligns with pre-existing software out there. So if it plagiarizes, for want of a better word. And this leads to a situation where you might have license requirements applicable to third-party code in the AI output. And you mightn't know who the copyright holders are, you mightn't know what the terms are. And in this case, you'd have to do a bit of scrabbling to catch up. Now, again, just to reiterate, while that situation may exist, it isn't a critical issue to using AI. It's just a thing for us to deal with. And then we have questions around, if we have AI generating code that may be aligning exactly with other code, appear to be plagiarized from it, how do you produce accurate SBOMs if you don't have a way to quickly determine the source of code, determine if it's third-party code? Now, this type of thing impacts not just license compliance, but also security. We're looking at a situation where something unpredictable might happen. And that means we need to have a way to triage it, we need to have a way to deal with it, and where something has gone sideways outside of our expectations, we need to have a plan to remediate around it. Now, as many of you will have guessed, what I've outlined here in terms of potential reproduction of third-party code with unknown provenance and unknown license terms isn't tremendously different from your engineering team copy-pasting from Stack Overflow. You're looking at fundamentally a lot of the same mechanisms to see what just happened here, and then what does that mean to me? When it comes to having accurate SBOMs and tracking things, again, you're not looking at a totally new item on your agenda. You're not looking at a paradigm shift. You're just looking at a fascinating new issue in that the machine can now potentially do things that a human might have done before. And we're not used to machines doing that yet. But as I said at the very beginning, this is fundamentally an area where we've got business processes ready, and we can replicate most of them from prior work. So the real challenge then is, how do we optimize, how do we take into account things like the unusual aspect of AI being either creative or potentially accidentally plagiarizing? and making sure that we have that neatly managed so we don't waste time and money doing unnecessary remediation and Scrabble at the last second. Joanna, back to you.
So I'm going to talk a little bit about, as it says, trade secret data and privacy issues. A lot of what we're thinking about when we're talking about the data issues are, there's a good saying that says, where you sit depends on where you stand depends on where you sit, i.e., it is really about what is your role in the overall, in the transaction and what's going on, is really going to define what sort of issues you've got. And so got up there some of the different types of things that are going to be considered confidential. And broadly, you've got essentially three big buckets to think about. The first is, if you're an organization, are you the AI vendor or are you the AI customer? If you're the AI vendor, you probably want your weights and your processes and everything to be considered secret, trade secret, et cetera. That can be difficult because right now weights are difficult to control under most sets of laws, and the government is suggesting that they should be very tightly held and considered to be core intellectual property trade secrets. On the other hand, if you're the consumer, the customer, a lot of times they will want to train on your data, and you don't want to let your internal company confidential data get out. Or maybe sometimes you do, but this is something that you want to be able to control. The third thing is that both of these parties may be in possession of third-party data that you may have various contractual restrictions on. For example, organizations regularly take in data from third parties, from other vendors, from upstream parties, where they say, I will promise that I'm going to keep this confidential. And then you need to make sure that those requirements that you've agreed to are going to be reflected in anything that you do, either as an AI vendor or an AI customer. One of the biggest issues here, and the one that I keep on bringing up because it is the most likely place where this is going to trip anyone up, is that some of the vendors, most notably OpenAI, if you do not engage a custom contract with them with different confidentiality provisions, and you've got any third-party data that's going to be interacting with OpenAI, either directly or indirectly through one of these companies that's basically a front end onto OpenAI, the second you fine-tune or do inference on any of that third-party data, you have breached your confidentiality provisions because they, by default, do not respect the confidentiality of any information that you give them. They have a one-way confidentiality clause. Their stuff is confidential. Yours is not. That means that if you're contractually required to maintain confidentiality, you can be, your customers or the people who gave you that data can assert against you. This is going to be particularly in cases where maybe you've got code that you're working from, and this code came from a vendor, and they're allowing you to use it as part of building your system. And you start to do this. You use ChatGPT. Someone uses ChatGPT. All of a sudden, you have violated your license to that code. You can actually be responsible for copyright infringement because you just steps outside the scope of the license. The other thing to really think about is personal information. A lot of when we're talking about in terms of data and restrictions on data is restrictions on data has to do with data in the whole, but personal information especially needs to be handled very specifically and very carefully. The biggest thing that you want to think about is that in general you want to make sure that if you've got confidential information, you do not ever want to train a system that is outside of your control with that information. Once you put something in a model, it can be regenerated. Even if it is unlikely, it can be regenerated. There were some instances, there's some up on the screen, where Samsung employees, and I've heard about another company where this happened as well, they put some stuff into ChatGPT, and then it must have been specifically unique because some other people prompted, and wow, and all of a sudden what came out were some of these Samsung trade secrets. And so they cut it off. Now, why did this happen? Because, in particular, again, OpenAI is particularly notorious for this. Anything that you do with OpenAI over one of their web interfaces, by default, they say we can train on the information that you give us. So anyone who's just typing stuff into ChatGPT on the web of any sort of information, you have just given them a license to train on that data, which means that if you put in individuals' information, you put in trade secrets, you put in anything, you have just allowed them to put it possibly into their model. Now, their API-related services, they say that they won't train on it, but you've still got that. You've still breached confidentiality unless you have a specific model. The final thing I wanted to talk about. This is one of the things that actually just in the past week or two has started to become increasingly important, is this idea of data provenance. Now, data provenance for anyone in the dealing with personal information or especially medical information or things like that, it's not a new issue. I've got a slide deck from 2017 that was discussing all this stuff. But what data provenance is not only, it's being able to prove how you know a fact, not just that you know it. And you have to be able to trace how a fact gets into from one system to another. And so you've got two aspects of this. The first is if you're doing any sort of training, there are some cases where people say, if you did not have rights to the data and you trained on it, because it is generally impossible to remove data from a model effectively, or the traces of a data from a model, there are some courts that have said, all right, that means that you need to throw out the model. If you want to do the same sort of thing, you need to completely retrain without that data, which can be astoundingly expensive. It's called model disgorgement. It's been applied by a couple courts now. The second thing is that if you are training and you've got some sort of restricted information, there's this idea of data blinding, where you need to be able to either prove or show with an arbitrary level of confidence that certain information was not injected into a model, was not passed along this pipeline. So expect a lot more interest around data provenance and data management as it goes through this chain. So I think that.
So AI tools are evolving to enable compliance and legal risk management. Amazon Code Whisperer. Oh, sorry. Hi. So the AI tools are evolving to provide features that help with these legal and compliance issues. So AWS Code Whisperer and GitHub Copilot are examples of AI tools that provide a code referencing feature. So they enable you to choose either you can filter out. You can choose not to see suggestions that match code that it was trained on, third-party code it was trained on, or you can allow it to show you those suggestions, but to notify you when the output matches publicly available code that it was trained on. And so that enables you to provide, first of all, to ensure that it's the code that's reproduced in the output is, if it's subject to third-party copyright, is subject to a license that's compatible with the open source project you're contributing to, or compatible with your company's own internal licensing and open source consumption policies, and then also to provide notice and attribution in compliance with the license of the third-party code. We're also seeing models for how LLMs are deployed and hosted in order to address some of the trade secret and data provenance issues that Van was talking about. So for example, Hugging Face has recently announced SafeCoder, and what this is it's an LLM that's been trained on a lot of publicly available, mostly permissively licensed code, but then you get, if you're a company who wants to use this, then you fine tune it on your own internal proprietary code, and you host it in your own virtual private cloud, and your prompts, your own internal training data used for fine tuning and the output from inference, et cetera. None of that ever leaves the company's, the adopter's private cloud. So it's for companies that want to use an LLM that has been trained on a large data set and then fine tune it in their own data, but then host and continue to maintain their own LLM.
So one quick note about that. If you are using something like SafeCoder or one of these other LLMs, make sure that you're looking at the license for the licenses for the data set. This is something that Joanna mentioned a little earlier. The license, and Shane as well, the license for the model, the license for the data set. Model especially, they've got some, the OpenRail family of licenses are becoming fairly popular. And the OpenRail licenses are in some very fundamental respects not compatible with open source and the open source definition. So there are cases in which you can, simply by using some of these tools, you can be arguably taking upon yourselves restrictions that are going to significantly restrict your ability to use open source code.
I think one of the interesting things about the market situation we're in is that we've run a little bit ahead in terms of stuff in market versus controls around it. And simple concepts such as access control layers to protect data aren't present in most LLMs these days. And I think that's a consequence of some really cool stuff happening really fast, but not being fundamentally architected on privacy or code segregation or data segregation. It's something that will be fixed, but it is noticeable as a market trend right now.
Yeah, that's definitely that's definitely so. And the other thing is that, to a certain extent, we have gone through a lot of this dance before. One of the things that I love about what Shane was saying is that no one needs to freak out. AI and AI licensing is just, in most respects, like open source licensing. We've done this dance. It's like it's like we're going through the late 90s and early 2000s all again with open source, and everybody's getting all up in arms about all the same things that they got up in arms about 20 years ago or 25 years ago. So we have institutional knowledge, but the important thing is that we need to make sure that we start applying that institutional knowledge and we don't go off like Chicken Little, the sky is falling, because if one of the things about AI is that it is so easy to start going off into sci-fi situations that you lose track of what are the real harms on the ground that can occur, that are occurring, and how do you mitigate those? Because it's really easy to think about risks. In fact, a lot of the risks that people are thinking of are the exact same risks that they thought were going to come as a result of the internet. And you know what? Those risks are out there. There are bad people on the internet. There are bad There's bad content. There are all the bad things that everyone worried about. And yet, it's fine because we also know how to deal with it. I guess if I would say one thing is make sure that you're not going crazy, that you're actually looking at realistic harms instead of theoretical ones.
Yeah.
With that in mind, what are policies? Now, this portion is going to be really focused on organizations, because a lot of times organizations are going to have a different risk profile than open source projects or individuals. If you're an individual, you may or may not care, honestly. If you're an open source project, there are only a couple things that you care about. If you're a company, there's a greater number of things that you're going to care about. And so your level of risk tolerance is going to define what your policy should look like. The other thing is to realize that any of these things are only current best practices. They are going to change. Any company that I've been working with has probably revised its AI policy 3 times by now. Like literally every 2-3 months, you have a new significant revision. So the best thing is to make sure that you are able to react to new situations and new circumstances as they come. So when you're looking at it, because different companies have different levels of risk tolerance, you're going to see a vast range of different policies. Some of these may fit you, some of them may not. Some say, okay, we're not going to use AI at all. By the way, that's a loser policy. AI is already in your organization. Some people are going to say, oh, we'll only use it for internal code. Maybe you can do that for right now, but just like open source, it's coming in from the bottom, and it's going to get into your into your products sooner rather than later. Some companies start to say only for internal code, internal systems, and not for stuff that is going to be shipped as part of a product. That is a distinction that maybe you can make work, because we've made that work in some aspects in open source. And so there's an existence proof that you can do this. However, just like with open source, how internal stuff sometimes gets exposed externally, you're probably going to have that same issue. Other people are going to say, all right, you are going to be able to do it, but we're going to train you. We're going to allow you to, we're going to try and create a way of doing this responsibly. And so I think that as time goes on, people are going to move more and more down toward this idea of train, responsible usage with some technological backup. But be aware that this may or may not be you. A lot of this goes also over that information that I was talking about different types of trade secrets, different types of data you really need to really be worried about. If you're really worried about this stuff, at least at this point, you can self-host a lot of it. You can host your own LLM. Now, some current best practices that I recommend, and I know a lot of companies have done. This first one is a lot of times, in order to, first rule of open source, for example, is you have to know what open source you're using. Same thing. If you want to deal with AI, you need to know what code was generated by the AI, or at least in part. For that, you can use a note in a commit message. You can use a marker in a file. You can use something like that. But know where the code is that has been touched by the AI so that you can deal with it specifically. Otherwise, by default, you need to treat all your code like that, and that is not going to be sustainable. These next two are tied. A lot of the issues are around essentially inadvertent copying and pasting, inadvertent copyright infringement. And the other thing is that people don't realize that most of the code that was trained on has CVEs, most of the code is security deficient in some way. And so unsurprisingly, most of the code that is generated is frequently security deficient in some way. It was the way most code was written. And so there are two ways to deal with this. The first is to use scanners on the AI generated code, both for snippet scanning, that's copyright infringement, and security. And the second one is to use test-driven development. What this does is, how many people know what TDD is? a few people. This idea of what you're doing is you're constraining the security aspects and actually the scope of what the generated code will be. That makes it both less likely to generate bad code from a security point of view and less likely to create an infringing code. The other thing is that copyrightability of code right now, as Joanna mentioned, this is not copyrightable in the US. So if you want to maintain copyright, i.e. you want to use a license for any of this code, you need to do two things. Number one, you need to make sure that a human edits it after the AI creates it, because that's going to create a copyrightable hook. And you want to make sure that that is specifically notated in the file or in the commit message that a human messed with this after the AI did it. And then the second thing is that if you are going to register the copyright, you need to disclaim, you need to say what parts of it were AI generated and then that humans edited later. You don't need to explain, provide diffs or anything, but you need to describe what it does. And then the last thing is that people are somehow afraid of, hey, we're going to lose context because of AI. AIs are great tools for actually helping your doc strings and your documentation stay up to date. Use them for that. So
thanks, Van. I'm going to talk about how some best practices for open source projects and contributors to those projects for legal and compliance. So first of all, use AI to augment your efforts, not to replace them. For many of the reasons that Van was mentioning, it's important to review and edit the code before you, whether you're using it within the company or if you're contributing it to an open source project, both for copyrightability reasons, but also to just ensure the quality, to ensure that it's suitable for the project you're contributing to, and for security and other reasons. Review the terms and conditions of the AI tool as well, to make sure that any restrictions on use of the output are not that are consistent with the open source license of the project you're contributing to and the open source definition. So I'll give you an example of terms that aren't compatible. So the ChatGPT OpenAI terms include some restrictions. One is that you can't use output of OpenAI tools to generate competing LLMs. Also, any content you publish, and yes, contributing to an open source project is a form of publication. Any published content created in part using OpenAI tools can't be related to political campaigns, adult content, spam, hateful content, content that incites violence, or other uses that may cause social harm. So even if you're not generating content that violates one of these restrictions and contributing into an open source project, the fact that those restrictions that exist are incompatible with open source licensing and the open source definition, because any restriction on use of software disqualifies it as open source under the open source definition. Consider including a notice somewhere, a notice or a tag that the file is in part AI generated. In part because, again, it should be human reviewed and edited. And that's in part to help enable downstream compliance, because ultimately the code that is in an open source project is going to be adopted by companies, right? And those companies may have policies like and practices like what Van was mentioning, where they're going to subject files that were generated in part using AI tools to additional compliance checks. So for example, they might go through additional snippet or security scanning. And so having some way to identify those either in the file or the commit, so that adopters can easily identify which portions of code were generated in part using AI can be helpful. Do you provide, this is not new, but provide notice and attribution if there are third-party materials included in your contribution to an open source project. This is not a new rule. However, again, when using AI, sometimes it's difficult to know, is the AI's output does it include third-party materials that you have to provide notice and attribution to, right? And of course, you make sure that if your contribution does include third-party materials, that they're available under a license that's compatible with the licensing policies of the project you're contributing to. Their AI tooling, I mean, vast majority of tools today, I think, aren't providing these features, but my hope is that more and more of them will. I mentioned earlier AWS Code Whisperer and Copilot as examples of tools that do provide features that help enable compliance. And so those enable you to you can either turn on a function that filters out suggestions that match third-party materials, or that an alternative feature is that it will notify you when there's an exact match, so you can provide notice and attribution. What happens when the tool flags multiple matches? So if you're using one of these code referencing features, for example, in Copilot or AWS Code Whisperer, it might produce a code suggestion, and there's like 50 different matches, right? And so what do you need to do? I don't think you need to provide notice and attribution to every single match. I think providing notice and attribution to one of them is adequate. That's because if you as a developer, if you were copying open source code from one project and contributing, modifying it and contributing it to another, that's completely okay. You're not required to research, what other potential projects in the world may also be using this snippet of code. Again, just the types of obligations that you have outside of AI, I think, transfer proportionately when you're using AI tools. And there is a variety of approaches to, how do you pick which match you're going to attribute to. And the company you're working for may have its own policies. So if they do, please follow those policies. If not, these are some examples of approaches. We don't, at the Linux Foundation and CNCF, we don't have a mandate regarding which of these approaches you should use in terms of either picking the oldest match or just picking any match that has a license that's compatible with a project you're contributing to. If the AI tool doesn't offer these features, there are other ways that you can get comfortable that the AI output you're contributing isn't infringing third-party rights. You could use a snippet scanning tool. That may even be a policy of your employer that all code go through snippet scanning at some point. You could confirm that the AI-generated output's not copyrightable subject matter. Something we didn't talk about earlier, but only content that has at least a minimum spark of creativity is even eligible for copyright. So, for example, just a mathematical equation is not copyrightable. And so, if there's only really one way to sort of express a function, it's probably not copyrightable subject matter anyway. And so that means that even if a third party had written code that was similar, if it's not copyrightable, you're not infringing their rights. So you might confirm that for other reasons. You might be able to confirm on another basis that AI-generated output is public domain. Or if you have sufficient familiarity with the model and the data it was trained on. For example, if it's a self-hosted, self-trained model, that might be a basis for getting comfortable that the output is not infringing of third-party materials. And your employer might have more stringent policies than these best practices. Do comply with those. And then individual projects. I think there are very few open source projects today, currently, that have guidance, very specific guidance on how to use generative AI tools. The Linux Foundation just published very high-level guidance with just a couple of recommended practices, and CNCF is working on developing more detailed guidance and best practices, and I think in the future more and more open source projects are going to be issuing their own guidance around how to utilize AI tools in a responsible manner for generating open source code. So you do check those policies and comply with those as well. And I think that's the end of the slides.
So how much time do we have left? What?
30? Oh, wow. Okay. Well, we
Well, does anyone have any questions?
I actually have a note while we're waiting for the first question to come in, if that's all right. And this note is based on something that I think is very important for context around what we're doing with AI. This is a field of tremendous hype at the moment, and rightfully so, in that there's a lot happening that's very interesting. But I think it's very important to remember that the hype leads us to perhaps regard this as a very special child, as something quite unique. And it's not. Artificial intelligence is artificial, but it's not actually intelligent. And in particular, things like large language models are simply guessing the next word based on what they've ingested, billions of data points. It, for want of a better expression, has no idea what it's doing. So we do need to put these things on certain rails to have effective, sustainable business practices around them. So I think it's very good to have a panel like this and to talk about some of the issues. And one takeaway is probably definitely that this is manageable. And second part, it must be managed. This thing isn't something that will look after itself. It's not something cognizant at all. It's just helpful when we guide it.
There is one question from the virtual attendees, but do you want to?
Go for it.
Okay. So Natalie says, what if your company has tagged the files as partly AI generated, but the code is accepted to a project, but not the annotations about AI generated? How to handle usage for open source software projects that do that?
Okay, so just to make sure I understand the question, it sounds like someone has generated some code partially using AI, and then they've contributed it, but the receiving open source project has not accepted some of these open source these annotations. I think in that case, a lot of what I would suggest is that you think about it at least in terms of, at minimum in terms of the way in which like the DCO would say. The DCO has this comment about, I recognize that I affirm that I have the right to contribute this code under this particular license. It is not, even when you are giving it under a license, you are still giving essentially that, even if you're not saying, I affirm this in a specific sentence, even if you're giving it, contributing it under any sort of other license, you're essentially giving that same warranty. And this is the thing that you would want other organizations and other contributors to also be doing for you. So both for legal and for community reasons, they are not required to accept anything that you provide. But I would say a person should take it upon themselves to make sure that even if someone didn't accept this particular annotation, that you've gone through and you've done all the necessary things so that it wouldn't cause someone else trouble downstream, i.e. you have edited it by a human. You have done appropriate scanning to where, scanning to make sure that things that you're giving are appropriate. You have done essentially enough due diligence that you would be comfortable giving this code to someone else and having them use it for whatever use that they would have for it, which can be anything under open source.
I'll add to that. So there are reasons. So you may notice that on that particular best practice, it said consider, not, please add a notice that this is partly generated using AI, but consider doing that. And that's because there's not consensus around that being, a required or best practice. In fact, there are some open source communities who prefer you don't do that. And part of the reason why is there are some open source communities that they're actually afraid of attracting copyright trolls. They don't want their repositories tagged with notices, oh, AI generated, because they don't want to attract the attention of copyright trolls who are going to say, oh, well, that AI tool you were using happened to copy, my work, and, therefore I'm going to, sue the project or adopters. So there may actually be policies that contradict that. So there are many reasons why an open source community may accept a contribution, but may not accept that annotation.
And just to note, legally, unless you are doing a copyright assignment where the project actually owns the copyright, they don't actually need to know. The only reason why, if I'm just licensing in my code, which is the typical way to do it, then the only time I'm actually going to need to make a declaration even is if I'm registering essentially my own code. If the project comes and takes out a copyright, they are not actually copyrighting any of your code because you own the copyright on it. What they are copyrighting is actually the selection and arrangement of all the code from all the various people put together, plus any code that they may incidentally own the copyright directly on. So they actually don't need to make that disclaimer because they're not actually copywriting anything. If Joanna is the project owner and I contribute something that was partially done with AI, Joanna can make the representation to the Copyright Office, and it is correct because she is not copywriting any of the code that I own copyright on, if that makes sense.
I also just want to acknowledge that open source is not necessarily perfect. I mean, we sometimes there's accidental infringement of patents that you're not aware of, or sometimes people who are new to open source and don't really understand how the licensing works may copy something from Stack Overflow that they shouldn't, and they contribute to a project, right? And they shouldn't be doing that if it's not available under an open source license, but these things do happen. So it's not perfect, but we trust each other in open source, right? We trust each other to contribute in good faith. And I think that same trust applies when we're using AI tools. We trust each other to use these AI tools in good faith. But that's also why adopters have additional compliance checks, because they know open source code is generated by humans acting in good faith who, aren't necessarily perfect. And now it's humans plus AI who are, AI can't necessarily act in good faith, but the humans operating the AI are hopefully, acting in good faith. And that's why companies adopting open source, they run the code through security scans. They run it through snippet licensing comparison and scans. They have their own compliance checks. Because they know this is community developed. We trust the community, but it's not necessarily perfect. It doesn't come with warranties, right? And so the adopter also has to do their own risk management.
What did you want to say, Shane? Did you want to say something?
Oh yeah, I just wanted to say one way to frame a lot of what we're talking about as well is on the sustainability issue. I mean, there's a lot of optional things. We can do this, we can do that. And without overloading ourselves with tasks, doing as much as reasonably possible. This alludes to what Van said about not kicking the can down the road is a pretty vital activity, particularly in the business space where, we often build something and think, well, this will be in market for 3 years, and 30 years later, it's still there. So trying to track where things came from and how we're managing them is extremely useful, not just for the next person, but in 5 years for the replacement of the replacement of the replacement of the next person to see what happened back in 2023. So a little bit of effort at the moment with tracking and tagging and having processes at this juncture will save us so much time down the road. And that's a lesson from open source, where quite frankly, we didn't get good at license compliance fast enough. And we spent years untangling that mess. Now we have an ISO standard for it. We didn't get good at security for long enough, and we're untangling that faster. But these are things where AI is very new. If we start getting things right now, we save billions and billions of dollars of effort globally.
Van, would you share what many of your, the OSPOs you work with are doing around recording like prompts and such?
Yeah. Well, a lot of so it depends on what sort of tool you're using. Most often, if you're talking about code, far and away the most common code assistant tool is Copilot. After that, it's Code Whisperer. Tab 9 also has one, but I'm barely seeing that. But usually, how does that show up? That just shows up as essentially here are some potential, essentially, completions of the thing that you're doing. And so you don't actually control a lot of the prompt in a Copilot sense or a Code Whisperer sense. On the other hand, if you are dealing with a more free-form response like a general LLM, then your prompts actually start to become very important, because your prompts can heavily affect the quality of what you're getting back, and can in fact be part of, for lack of a better term, the secret sauce in what you're doing in terms of being effective as an AI tool user. And you can actually go through and have several rounds of revisions on these prompts and actually to make them useful. When prompts are developed iteratively like that, in some cases, prompts are being considered code. They're the input to a code generating facility, just like, well, we already have code generation facilities in open source and in software. They've been much less flexible, but they've been out there. Even simple include files and macros, those are code generation facilities. And so what do we do with them? We write tests around them, we track them, we revise them, we sometimes have specific things. The nice thing about doing this with LLMs broadly is that you can actually start to have revisions on prompts that you use for things like image generation and text generation. Some companies are actually starting to use to train and fine-tune things on their own corporate style, their own corporate language and the way they use language, so that when they when they use a tool to generate a blog post, it doesn't come out sounding like Bland McBlandface. It sounds like like their own style, their own voice. And so you can actually start dealing with those things similarly to code.
Any other questions?
All right, so I think we can have like a 20-minute break until our next panelist. So our next panelist is Mirko from LF Europe. He's going to be presenting about the recent policy updates in EU and how it affects open source, not only for organizations within the EU system, but also outside for those organizations selling also in EU. So that will be at 1, from 1 to 1:30. 20 minutes break, plenty of time to think of topics for the roundtables and conferences. So right now, the flip chart is empty, but just to give you some examples, you can add topics like the ones we have been discussing during these presentations, or outside the legal stuff if you feel more comfortable talking about any other topics, things that are right now critical in your organization, not only around AI, but also around any other broader topics. So it's on conference styles. I think since we are a few, maybe have one big table will be enough. And yeah, so 20 minutes break. See you. Thank you so much, Joanna, Van, and Shane, who is dialing from Japan, and it's super, super late. So thank you so much. And let's see you, in 20 minutes. Thank you.
Thanks.
Thank you. Good day.